30 days, my lord. They have made a calculation by taking 30 days. I have shown in the last occasion, my lord. And under the Minimum Wages Act as well as the ESI Act, it is 26 days. So there arises a price difference.
In anything matter, my lord, he became L3 lordship.
That's an admitted position, my lord.
Whatever it is.
Lordship, to that effect, lordship, we require to file an affidavit on that regard, lordship. Now, the question is, the status quo is given by lordship. His term has expired, lordship. Now, this is for cleaning of train, lordship. So I pray, lordship, let whatever order may be passed subject to the outcome of the petition and notice may be issued. We have to file our affidavit to clarify our statement. That is my.
My lord, I am working. I am the existing contractor.
His term
By
is
virtue
over.
Exactly, my lord. There is no dispute on that. But by virtue of your lordship's order, I am continuing, my lord. Let them give. Lordship will give a short date, my lord. Lordship will finish.
Lordship,
1 minute.
one thing, lordship. Kindly see his prayer, lordship. There is no prayer for extension of his time, lordship. Okay. And his term has.
Extension. I am not praying for extension of my thing.
And there are, lordship, I have records, lordship. Their performance is so poor, lordship. We have various complaints against it.
Immediately complain.
The period is over, lordship. That's it. Nothing is there.
Respondent 2 is L1.
Yes.
Respondent 4 is L1. 4 is L1.
Respondent 4 is L1.
L1.
I am paying for respondent 4.
Okay.
So let them, status quo may be withdrawn, lordship, is subject to outcome of the
He
petition.
cannot, my lord,
May I
continue, my lord, with the existing contract, my lord.
May I
His
submit?
term is over, my lord.
May I submit?
Yes.
Well, the decision taken by the railways, ma'am, it goes to the root of the matter. My specific contention is that the price quoted by the L1 and L2, ma'am, it will not even suffice the minimum, ma'am. That is my.
The issue is this, you have calculated on the basis of 30 days.
Yes.
But as per the act,
Lordship,
it should be 26
26.
days.
then lordship, we have to calculate,
Then why not you do one thing?
Lordship.
You file your affidavit.
lordship.
We'll take it up next week on Monday or Tuesday.
Lordship,
Let it be
then,
on Tuesday, ma'am.
lordship, it is, we have some.
Kindly see, my lord, there is a status quo, my lord.
No, that's
There is a
fine.
public,
Considering
safety
that, considering that there's some urgency involved
Yes,
in
ma'am.
this writ petition,
but it-
instead of issuing notice
Yes,
at
madam.
this stage, since you are appearing on behalf of the
respondent 4, my lord.
respondent number 4,
L1, my lord.
1 minute.
Who
Who's
will-
5?
5 is the L2, madam. Lordship has not issued notice, so that's why.
So the LOA has been issued in favor of me, my lord. Because I am suffering, my lord.
Yes.
Huge.
R5 is an,
He's a L2, my lord.
He is L2, ma'am.
L2, my lord.
He is also not meeting the requirement, minimum.
Now, madam, if we go by the records, my lord, of the petition, my lord, if you see, my lord, there is a big confusion arises with regard to my race giver, my lord.
There
There
are
is no confusion.
26 days in a month, my lord, a worker
I'll
can work.
clarify everything, my lord. There is
and for the 4
absolutely no
days, my lord,
confusion, my lord.
Who will pay, my lord?
The railway has to pay.
Railway has to
lordship.
pay, my lord.
So
To me, my lord,
therefore, we have to calculate for 30 days, lordship.
Absolutely
Taking-
misconceived, my lord.
for taking out a 1 day, my lord, it has to be divided by the 30, my lord.
will issue not, but can you take Dusty? No.
Dusty will be difficult.
On R5. He's from Madhya Pradesh.
Not
You are from?
I am from Delhi, my lord.
There are 8 readers, lordship. No one come, lordship. Only he has come. No one has any grievance. Is
That is a different issue, my lord. If no one comes, my lord, that blame cannot be put on me, my lord. Why I have come?
My lord, the railway has also clarified the issue, my lord.
In his
My lord, kindly see, my
annex,
lord,
lordship.
Page 157, my lord, for a moment, my lord, the railway has clarified the issue, my lord.
That part we have considered the
Yes, my
ability.
Exactly.
And 139, the POQ, my lord.
Lordship, to clarify everything, Lordship will kindly turn to page 165. This is the wage card issued by the railways in another contract, my lord.
This is on board,
But
lordship.
let me submit.
This is
Let
on
me
board,
submit.
lordship.
Lordship kindly takes up
This
the
is not a
fourth
standard,
column, my lord. Monthly wages 26 days. Lordship has got it.
But there the race giver was not taken into consideration, my lord.
Yes.
It is 26 days, my lord. Lordship has seen the Minimum Wages Act rules, my lord. The 7th day is included, my lord. Issue is like this, my lord. On the 7th day, that particular workman will not work. Someone else will have to fill in.
My lord, compare with
So
139. my lord.
one worker may work for 10 days, another may work for 20 days. someone will work for 26 days. So that is why the daily wages, my lord. The calculation made by them, they are giving less benefit so far as PF and ESI.
Where's the LOA?
LOA is not part of the record, my lord. We did not get a copy, my lord. We have made a statement that we have not received a copy.
This is the LOA, no? Okay.
Let it come on the form of an affidavit. Let the stand of the railways come in the form of an affidavit, my lord. I also get a chance to
Why am I
respond.
harping, my lord?
No,
Because
no, the issue is this, R5 will have to be heard.
Yes,
What I will have to.
in
Then in that case, notice has to go.
yes.
My lord,
But in the-
I'll try to make a paper publication, my lord.
No,
Or
that's-
if I get an email, my lord, I can send it by email.
no, that's fine. Do you have an email of the R5?
I find email, they will have, my lord. Let them provide.
The whole issue is this.
Exactly.
Your L?
3, my lord.
L3, my lord.
Three. And he's L1.
L1.
So you're challenging his LOA,
Yes.
correct?
His LOA as well as the bid of the R5. I am saying that
Now,
they,
the issue is this, whether it is whether the quoted rate
Yes,
of the R4 is acceptable to the railways.
Yes, my lord.
Yes.
It's the only thing
Yes.
that is to be concerned.
Yes.
Considered.
correct,
Correct.
correct.
So, by giving a status quo order as on today, you are proceeding with the work.
Yes.
Yes, my lord. That to in the existing contract, my lord. That he cannot, my
If your
lord.
lordship
Your
permits me.
contract is over.
My contract
Yes.
is over. My contract admittedly over. my lord. What I am on is the rate quoted by the bidders has to meet the statutory requirements, my lord.
So the LOA issued in favor of the respond number 4
my lord.
shall be subject to the outcome of
Yes,
this.
my lord.
If he continues, my lord, my repetition becomes
no.
infructuous, my lord.
No, I'm making it clear. It will be subject to the outcome
My
of
lord,
this.
it's a matter of 1 week, my lord. In 1 week,
No,
they
no,
will not
no.
be able to take over, my lord.
1 week is not the issue. The issue is the notice on R5.
Yes.
I'll serve, my lord. I'll serve by email, my lord.
Lordship status quo will
Lordship will take it up on Tuesday next.
Tuesday,
Let
Lordship.
them produce the records.
Lordship, today itself I have
We'll
the
try
records,
to
Lordship.
finish the audit petition, my lord.
You have the records with you?
Yes, your Lordship. But Tuesday I have some difficulties, Lordship. 18, 19, 20, 21.
It need not be a hearing day.
No.
Then on Wednesday, my lord.
I'm-
Monday,
Monday, I have some
Lordship.
difficulties. Let it be on Wednesday.
Lordship,
It is subject to outcome because the LOA has been issued by.
no, 1 minute.
Lordship,
If
because
we can hear it, if we can hear it by Wednesday,
Yes.
Lordship, we have to
status
file
quo
our
will continue.
Lordship.
No.
It cannot be Lordship. We have to file our affidavit, Lordship.
So you file your affidavit.
Lordship.
If on the next day, if there's any adjournment, then I'm going to change the status quo order.
Lordship, now because their contract period is over, Lordship. How can they will continue, Lordship? There will again payment. There will be railways.
But
He will pay, Lordship, this day.
but the chaos
He
is-
will again claim damages against us, Lordship.
Yeah. Okay, heard Mr. N. They call and counsel for the petitioner. Issue notice. Mr. S.S. Roy, Leonard, CGC, enters appearance on behalf of respondent 1,
2 and 3.
2, and 3. And Mr. S. Botakur, Leonard Counsel, enters appearance on behalf of the respondent number 4. Extra copies.
I'll-
Petitioner to take steps for service of notice on respondent number 5 by
I'll take by registered port as well as by email, my lord.
by registered post AD within a period of 2 days
2 days.
from today. Additionally, comma,
26.
the petitioner is also permitted to cause service of notice on the respondent number 5 through the
Email address,
through
which they will
the-
provide, my lord.
through the registered email address
If it is
Uh,
there, we will provide.
uh,
Absolutely.
of the to the registered email address, which shall be provided by the railway authorities. Stop. List the matter on.
26, Lord.
26 or 19.
No, I will not.
You're saying there's an urgency involved, and then you are
Lordship, I will
extending the
be
date.
out of station from 18 to 21, Lordship. That's why. Lord. On 25, 26,
That week, my lord, any day, no difficult.
25, 26.
Okay, on 25. When did his term expire?
Is
This month.
expired- This month.
No,
31st.
Madam,
on 20th of February.
20 February, the term is over, my lord. Now he cannot
Matter of
continue,
only-
my lord. But the railway station cannot be kept in such a situation, my lord. The public safety is involved, my lord.
Their water, we have to keep.
Okay.
That's why, my lord, it may be, my lord, subject to outcome of the petition.
Letter of acceptance.
My lord will kindly consider, my lord. I am working.
No,
No,
my lord,
I'll
he cannot
continue,
be,
my
my
lord.
lord.
He has to come in with his new set of laborers, my lord.
Let us see how they can manage.
Yes, my
The letter of acceptance issued in favor of the respondent number 4
yes, my
shall be subject to the outcome of this writ petition. List down. When do you want? Let us have it,
24th,
let us have it early.
25th lordship.
And that is why I was praying for 19th, my lord. For this
19th, I
personal-
will- I will
personal
be out of
inconvenience,
station.
my lord.
Okay, 25th.
Problem. So,
May it please your lordship. Lordship, the matter pertains to central capital investment subsidy scheme, lordship. We had applied for the claim, but then it was rejected in the SLC meeting. But our amount is less, and the amount automatic approval is still 1.5 crores. Our amount is much lesser than that, lordship. It is only 17 lakh. In similar cases, lordship, I have already attached the order, lordship. Will find the similar order at
Page.
page, lordship, 69. Lordship. On the last occasion, they were about to obtain the instructions, lordship, whether my case will be covered by this order.
Kalita, you have any instruction?
The lordship, what has happened is that like it cannot be, it cannot be directly said as covered case, because what has happened here, lordship, in their application that they have made a small mistake there. Like they have been given the amount for VAT.
Mm.
So that's why the SLC has taken a different view. Now, lordship, since they have placed this, materials on record, and they have applied to the Industries Department again, and GM has already forwarded those documents correcting those, the figures. So like that Industries Department will consider it. It will not be done as a covered case, but like they already consider it.
The order is that only, lordship, it
No,
will
no,
be
I mean-
reconsidered.
No, it, yes, now since they have corrected it,
Then what we can do?
we'll reconsider it on the basis of their papers. That we can do. But it will not be a covered case
It's
directly.
not a covered case.
Not a covered case directly, because their contention is that they did not put the value of VAT that
Hmm.
they have paid. So that has to become there on the record.
Then you
And
file
now-
file a small affidavit. On that basis, we'll dispose it.
But my lord, whatever affidavit,
No, lordship, what it can be that can be done is that now, if lordship comes to page 68,
Yes.
68 lordship, now GM has already on 2nd of January, GM has already placed those documents before the Commissioner of Industries. They have resubmitted those documents, lordship, where they have done some mistakes. They have probably corrected the mistakes, and like now they have placed those things before the GM, and GM has already forwarded it to the Commissioner of Industries on 2nd of January.
Okay.
So it will be considered.
When are you considering? When is the SLC sitting?
SLC lordship will sit on the need based lordship, because
Okay.
like this scheme is already over.
Oh,
So if there are, because they have gone for commercial production within 10 years, span of 10 years, so their case will be considered. So now I cannot, say the exact date,
okay.
but like, it will be considered. It's only on 2nd January. Lord.
Okay.
yes, my lord. In the next SLC, they may
Yes,
consider my
yes,
SLC, they may consider.
Okay.
But my lord, my only thing was that he's saying that mistakes are there in the paper and I'll get less amount.
That is their,
That
that is their contention. They have placed those papers there.
Yes, my lord.
Uh,
But that question is, my lord, this scheme says for automatic approval till 1.5 crore, and my claim is only 17 lakh. So where is the question of SLC taking any decision on it?
That will be seen, by, considered by, because they have only placed this.
That is the similar
Lordship
order
can
that
only
we
say-
have placed. That is in the similar order also. It has been said when it is a case of automatic approval.
They
lordship.
want only
Where is the-
reconsideration, the SLC is going to reconsider it. What is the problem there?
Yes, my lord.
Their
May-
paid is only that only. Now there is no point complicating the issue.
In the next SLC, it may be reconsidered, my lord, in view of the order of this High Court.
Where's the rejection by the SLC?
Lordship will find it page 62. Serial number 6, your lord.
Serial number?
Six, lord.
What is the ground?
IT return power VAT that has not increased as per the expansion. The main issue was regarding VAT, my lord, but we have submitted the papers. We have paid much more VAT than the previous year. my
So it was their mistake now. They have resubmitted those documents to the SLC, then the department will consider it.
Okay.
That's all.
Hurt MS,
ML Gop. ML Gop.
ML Gope, Learned Counsel for the petitioner. Also heard Mr. A. Kalita, Learned Standing Counsel, Industries and Commerce, isn't it? Anybody for the union? And Kalita, A. Kalita, Learned Standing Counsel, Industries and Commerce. For the respondents, 2, 3,
2, 3, 5, and 6.
2, 3, 5, and 6. How about the Texas? Stop. Para. The present writ petition has been filed by the petitioner challenging the minutes of the state level committee, challenging the minutes dated 31/2019 of the state level committee, whereby the claim of central investment subsidy of the petitioners,
Central Capital Investment.
central capital investment subsidy of the petitioner's firm under the Northeast Industrial and Investment
Policy.
Promotion Policy, within bracket NEIIPP 2007, and Central Investment
CCIS.
Subsidy Scheme,
Central Capital Investment Subsidies.
Central Capital Investment Subsidy Scheme 2007, for the modernization process was rejected. Stop. It is the case of the petitioner that the petitioner's firm has undertaken the modernization process in its existing industrial unit by introducing the latest technology, and therefore the claim of the petitioner under the claim of the petitioner for subsidy under the CCISS 2007 could not have been rejected on the ground that there's no increase in
Indeed.
VAT for 1 year after expansion compared to 1 year prior to expansion. Stop. Learned counsel for the petitioner, however, submits that after the rejection of the case of the petitioner's firm, the petitioners have submitted the claim proposal after making rectifications wherever necessary. Stop. Draft, comma, the general manager, within bracket, in charge District Industries and Commerce, Center, Tinsukia, by a forwarding letter dated 2nd January 2025, addressed to the Commissioner of Industries and Commerce, Assam, has forwarded the 30% CCI, 30% CCISS claim in respect of the petitioner's firm. Stop. Para. Mr. A. Kalita, Standing Counsel, Industries and Commerce, submits that as the petitioner has already submitted the rectified claim application before the concerned authorities, before the general manager, District Industries and Commerce Center Tinsukia, which was also forwarded before the Commissioner of Industries and Commerce, Assam, on 2nd January 2025. The matter may be closed by directing the concerned SLC to relook into the matter. Stop. That much will do, considering the submission made by the Learned Standing Council, Industries and Commerce. This writ petition is disposed of, directing the state level committee to have a reconsideration of the case of the petitioner in view of the submission of the rectified claim proposal made by the petitioner's firm. Stop. I can't give a date, so you don't know when the
That cannot be given.
let such consideration be
The
done
next state level,
in the immediate next sitting
Yes,
of the
next,
state level committee. Stop.
the previous rejection may be set aside.
Hmm?
The previous rejection may be set.
That is
No,
not
that is
required.
not
That
required.
is
That
not
is not
required.
required. We haven't gone to the merit
With
of the
the,
matter.
with the above restrictions and directions, with petitions disposed.
Look, three similar matters.
The three, there is a problem. Lord.
See?
There's
Yes.
another matter also, item number 3.
Huh.
There's a huge delay there approaching the court. So like I will have to file an affidavit in this delay.
Okay.
Delay.
Then you want to issue, we will issue notice?
Yes, issue notice. Lord.
Third MS ML copy, learn counsel for the petition. Issue notice. Union who accepted notice for the union? MS RDV, learned CGC. Enters appearance on behalf of the respondent number
One.
one. Correct. Comma. Mr. A. Kalita, learned standing counsel, Industries and Commerce. Enters appearance on behalf of respondents 2, 3,
2, 3, 5, and 6.
5, and 6. How about 4, Texas? Do they have a standing counsel?
Gogoi will
B.
okay,
Gogoi.
okay, okay.
And
With
Mr.
the-
B. Gogoi, understanding counsel, Texas, appears for the respondent number 4. Notice on respondents are complete, however, extra copies. Respondents are allowed to file affidavit. List after 4 weeks, 3
4
weeks,
weeks. 4 weeks.
4 weeks.
Matter play.
19 of supplementary list, motion.
By the way, the tender was floated by the respondent authorities. The petitioner also participated in the state tender. And thereafter, my lord, the technical bid was evaluated. And the petitioner was informed that your technical bid has been rejected. No reasons were given. Thereafter, petitioner wrote to the authorities that to give the reasons. That what are the reasons for which, my lord, the tender was rejected. Ultimately, my lord, the petitioner was informed that the tender was rejected for the reason that another tenderer who was in the same building, my lord, who used the same IP for the purpose of submission of the tender. On that ground, the tender has been rejected. Now, there was no tender conditions that the same IP address cannot be used. Only one condition is there at page 212. page 212, my lord.
Hmm. Yes,
Clause 8.3, my lord.
8.3.
3, my lord. May I read, my lord?
Hmm.
Policy practice amongst bidder prior to or after the bid submission means a scheme or arrangement designed to establish bid prices at artificial non-competitive levels and to deprive the employer of the benefit of a free and unpaid competition. Now, my lord, in this case, after the financial bid was opened, my lord, I found that my bid is much lower than the 3 bidders. Now, here, my lord, to deprive the buyer of the free and open competition, my lord, when the bid price is much lower, then how the buyer is deprived of the free and open competition? Simply, my lord, they have left to examine and find out whether any collision nexus was there with the bidder or not. Without that, the bid cannot be rejected. In fact, my lord, similar petition came up before this lordship, my lord, in respect of the same tender, wherein another person was the lowest bidder. My lord.
Where is the tender notice, NIT?
My lord, NIP yet you will also find at page, my lord. What to say? Appendix. It starts with, my lord, page. Annexure 1, page 33, my lord. 30, 31, my lord.
This is what date?
Wait a minute. 7/9/2024. In the 3 million section, there are 5 million total different types. And in 3 million, I was the lowest. I've given the chart also, my lord. And in this case, you'll find in respect to the same tender, in respect to the another item where the petitioner was the lowest bidder, the court issued notice and directed that no final orders will be passed.
Yes.
Lordship, I am just a formal party, in fact, in this matter. So actually, this is Purva Bharti Gas Private Limited. Is
In
the
that
main
case
party,
also-
and Mekon Limited is a agency who is conducting this.
The same, my lord, in the earlier case was the same parties.
Okay. Same parties.
Only thing
Same
is that,
parties.
Lordship, only thing is that, Lordship, they have the reasoning they have given is a collusive bidding.
I correct, but this is a,
My learned seniors already stated so. So that is the point they have given.
but collusive practice, they must arrive that after examining the, my lord, the financial bill, that how it is collusive practice.
No, you are concerned with which item?
Well, the item my loss will find price bid comparison, page 277. Well, lordship may observe the items in which the petitioner is the lowest bidder, my lord.
Hmm?
Lordship may observe that, my lord, the items in respect of which the petitioner is the lowest bidder. I have given, my lord, in the side, my lord, difference 1, 2, 3, the last 3, my lord.
You are the lowest bidder
Three, my lord,
in 3 items.
my lord.
No, which are those items? That I
Yeah.
want to know.
It is mentioned in the chart, my lord.
Because if an interim is issued,
My lord.
it cannot be a blanket
My
interim.
lord, Your Lordship, my lord, in respect to the item where the petitioner is the lowest bidder. The petitioner is the lowest bidder there only.
For how many items
Three items. Three.
you participated?
My lord, I participate for 5 items,
5 items.
my lord. Only in 3 I am the lowest bidder.
So which are those 3?
I will do one thing. I will give the 3 item
Okay,
number.
we'll take off after some time. You just
Well,
go
just
through
wait.
and come. After some time.
4 of daily list, admission, partial matter.
Blood, it was already
It is a
heard
video conferencing.
and Lordship was awaiting for their said instruction.
Mm.
This morning they have filed an appeal.
Oh,
This morning probably it has not come up on report.
they filed the affidavit.
They have filed an affidavit. They held, right?
Oh,
So let it
Which-
come up day after tomorrow. With the affidavit, we'll finish the August.
okay. Day after tomorrow, we'll have it on Tuesday.
Sorry,
Tuesday,
next Tuesday.
Ah.
What is it?
18th.
18, yeah.
Who filed the affidavit? Health,
Health. Department of Health.
additional affidavit.
Additional affidavit. Lordship wanted that once they were found fit, then they were found unfit, then again you have found them fit.
Heard Mr. K.K. Mandal and a senior counsel, assisted by Mr.
S. Gautam, Your Lordship.
S. Gautam, then the counsel for the petitioner. Stop. It is submitted that the Health and Family Welfare Department has filed an additional affidavit this morning.
This one.
This
This
morning.
morning.
Stop. Registry to verify and place the same on record. And list the matter on 18th March.
H,
May I please, Your Lord?
Hmm. Yes.
May I please? My Lord, these petitioners are in a difficult situation. Originally, my Lord, in 2018, they were allotted an area for quarrying, 10-ton quarrying. So they worked for some time. Thereafter, they were asked to shift to a new place. My Lord, this is governed by this mineral rules of Assam. So you have to make a plan, mineral plan for the thing that has to go through different channels, and they have to approve, then only you start the work. So the first thing was also gone through that process. Thereafter, we were asked to shift, and there was some litigation, and pursuant to that decision, and also their own finding, they asked us to go and start the work in a different place. We complied with that order. Again, we have to make that mineral plan under the rules, and that has to again go through all these authorities, which was done, and they have allowed. And we started operating. Then suddenly this impugned order comes. Stop. Because of a Supreme Court order. The order is not given to us. We have not been heard. We are not given any opportunity. And our now whole thing has come to a standstill. We are at a loss. Our laborers are facing great hardship, over 100 laborers. The product is very important now for many development works. So, and the rules require, if you want to suspend, you have to give notice. Apart from natural justice requirement, there is a specific rule also. That also is not given. And it is, and they say that initially first it was moved, they said that there are judgments of the Supreme Court and they have annexed with the affidavit 3 judgments. And your lordship will find in those judgments that it relates to illegal mining. Ours is not an illegal mining. Kindly just have a look at the annexes for a minute, Miller. The first, at page 19. I'm really surprised, Miller, that this is how they deal with these local operators. Page 19, Miller.
Hmm.
It is dated 2/3/21. Approval of mining plan along with progressive mine closure plan in respect of Nopani Monsa Inti number 1 Stone MC area 3.448 hectares in Karbi Anglong district, Assam state, submitted under Rule 5152 of the Assam Mineral Rules, Concession Rules 2013. This is by the director to the Divisional Forest Officer, Director of Geology, Mining. He is the competent authority under the definition. One director, Geology and Mining. In exercise of the powers under Rule 5152 of the Assam Mineral Concession Rules, I hereby approve the mining plan, including progressive mine closure, prepared by RTQ, Dr. Abhijit Bara. This approval is subject to the following conditions. So he approves the mining plan, and he says that and item 6 and 7, it is restricted to 50,000 cubic meter of stone for 5 years. And educate number 7, educate number of check dumps and retaining wells shall be made to make and maintain in good condition to prevent any anticipated detrimental impact on water regime. So that all these conditions are there. And then item number 13, Divisional Forest Officer should confirm that the lease area doesn't fall in the National Park, Wildlife Sanctuary, Game Sanctuary, Bird Sanctuary, including eco-sensitive zone, and does not affect the animals, birds, biodiversity in any way. So then an approved mining plan along with progressive mine closure. So this is by the director, Milord. Then kindly turn to page 21. This is by the DFO to the chairman of State Environment Impact Assessment Authority. They are the authority, Milord, who goes through all this. Issue of environmental clearance certificate against the Nopani Monsa Inti number 1 stone MC area relocated. This is the new area, Milord. Nopani Monsa Inti number 1 stone MC. Then Milord, he writes to the chairman, with reference to the subject cited above, I have the honor to inform you that the Nopani Monsa Inti number 1 MC area which is relocated from the original area was this, Milord. Fonglangso Stone MC area, as per CEC direction in the meeting of 24/7/2018 regarding relocation and shifting of the approved mining plan, which was settled in favor of Srimati Kadam Tengpi, the petitioner, Milord. In this connection, the contractor has applied additional quantity of 50,000 metric stone from his allotted reallocated stone quarry MC area located as per approved mining finding under reference, and the additional quantity recommended is 50,000 cubic meter stone for 5 years as per provision of Rule 52(1) of the Assam Mineral Concession Rules on environment impact assessment, environment clearance certificate to be submitted by so. The proposed site, this is important. The proposed site has been recognized as non-agricultural bare land, and the proposed site is outside the 10-kilometer eco-sensitive zone of Kaziranga National Park and does not recognize as no development zone. Besides, there are no permanent elephant corridor in the vicinity of the proposal site. In this regard, I would request you to kindly issue environmental clearance certificate in connection with the contract area of Nopani and all that. So the approved mining plan was sent. So this clearly is a confirmation of the location that it is outside 10 kilometers of the eco-sensitive zone and does not recognize there is no agriculture and all that. This is their case while giving it to us. Now kindly see the next, page 22. This is again given by Government of India, Ministry of Environment, Forest, Climate Change, and the State of Environment Impact Assessment Authority, Assam. This is the particular authority below to judge the impact on environment. Subject is below grant of environmental clearance to the proposed project activity under the provisions of notification dated so. This is in reference to an application for environmental clearance in respect of the project submitted to SCIAA, that is that organization, by proposal number so and so. The particulars of the clearance granted to the projects are given, and the project details along with the terms and conditions are appended here too from page 9 onwards. So this authority, Milord, it is called SCIAA, and they have given the environmental clearance. And then, Milord, next page. This is a reference to an application for prior environmental clearance proposal number so-and-so along with so-and-so with map with GPS coordinates and other relevant documents for collection of stone from Nopani area under western range of Karbi Anglong East Forest Division, Difu District, Karbi Anglong, Assam. Kindly make a little note because this may crop up at some time. It is western range and Karbi Anglong East Forest Division. This will have some significance with it. I am therefore drawing your lordship's kind attention. And then, Milord, the longitude and latitudes are given, the location is specified, and the other conditions are then set out. And then the conditions are in the next page below. Item condition number 2 at page 24. concerns, my lord, the leaseholder shall undertake adequate safeguard during collection of stone and ensure that due to this activity, the hydrogeological and ecological regime of the surrounding area shall not be affected. Regular monitoring of groundwater level and quality shall be carried out around the mine area during the mining operation. If at any stage it is observed that the groundwater table is getting depleted due to the mining activity, necessary corrective measures shall be carried out. So this is one of the conditions. Then, my lord, the other conditions are there. I need not trouble your lordship with that now. How the extraction will take place, when it will be done, all these are given, my lord. And what materials they will have to, machines they will have to have in that to control the dust and all are specified. Then para 6, my lord, item 43. Condition 43, my lord, at page 26. The project proponent shall ensure that no natural water course gets obstructed due to mining operation. Because I find that they were talking something about water level. These are all part of the conditions.
You are reading from?
My lord, page 26,
Mm.
condition number 43. The project proponent shall ensure that no natural water course gets obstructed due to mining operation.
Okay.
Then and 43.8 also with regard to water in the surrounding natural water channel doesn't get disturbed and water doesn't get polluted. So these are conditions, my lord, I have to do, and they have to also consider and monitor. If they find something wrong, they take steps, my lord. There is nothing, no inquiry, nothing of the kind. So this is how it was done. And the next page also, the conditions are there, my lord. I need not trouble your lordship with this. And only item 8, my lord. Environmental clearance is valid for a period of 5 years from the date of issue of this order. So they have given the environmental clearance and it is valid for 5 years. So it is still valid. Then kindly make a little note of condition number 11, last condition. Divisional Forest Officer, Karbi Anglong East Forest Division, Difu, District Karbi Anglong, shall realize the royalty as per existing rate, and he should ensure to mark the proposed mining area on the ground, fixing pillars as per GPS coordinates before allowing actual operation, as mining is restricted outside the limit of the approved mining site. So this is also a condition, my lord. And the authority which is being entrusted with this is, my lord, kindly make a note, because this will have some significance when that Supreme Court order will be placed by me, my lord. They have annexed it, I'll place it. So it is Caribbean Divisional Forest Officer, East Forest Division, Difu, who is going to be the authority looking after, and also, my lord, the person who will be responsible for this. Then kindly turn to page 29. This is by the Pollution Control Board of Assam. This is consent to operate, my lord. They are the authority who can give this, and they have given this, my lord. And the consent to operate under Section 25 of Water Prevention Control Pollution Act 74 and Section 21 of the Air Prevention and Control of Pollution Act as amended and rules framed therein is granted. And then, my lord, the details are in the accompanying pages at page 30. Product is stone, my lord. Period is 5 years. And then the terms and conditions. And they have noted, my lord, that in the last column, my lord, 11, 10, 14, Roman 14, that NOC from SEIAA, which I have already shown your lordship in the text. Then the terms and conditions, my lord. It is for valid for 5 years. And clause 3 at that page below, last clause at page 30, that refers to the provision by which, my lord, the authority concerned is always has a right at any time to enter the unit premises for inspection, collection of sample for analysis, and make a call for information as deemed necessary. Denial of this right will cause withdrawal of the CTO. So they have all the authorities, because they can ask us whatever they want, and if we can't fulfill, they will withdraw this consent. And nothing of that kind has happened ever. And next clause, my lord. The 5 years is again, my lord, reiterated. The noise level they are providing, and the time during which it will be done also is specified, next clause. And CTO may be modified, suspended in whole or in part, or withdrawn by the board during its term for cause including but not limited to the following as violation of any terms and conditions. So that is there, that clause. Nothing, no allegation, no complaint, no inquiry, nothing of the kind. Then page 32, they are reiterating at condition 12, my lord, that the Assam Mineral Concession Rules 2013 is applicable and all that. And then, my lord, if your lordship just have a look at that impugn order. And we started operating, my lord, after all these clearances have come, after we were shifted. This is on 29/10/25. Issued by, my lord, the Divisional Forest Officer. Suspension of mining operation in the stone quarry falling within the proposed eco-sensitive zone of Kaziranga National Park and Tiger Reserve and within default eco-sensitive zone of Kaziranga National Park and Tiger Reserve. So this is addressed, my lord, by the DFO to the range officer, Northwestern Range, Parkap Pahar. This is our area, my lord. Parkap Pahar is the area where this particular quarry is there. And it is Western Range and Northwestern Ranger. This is the. Then, my lord, in persons of the above, kindly see the decision also. And the subject, suspension of mining operation in the stone quarries falling in the proposed eco-sensitive zone of Kaziranga National Park and Tiger Reserve and within default eco-sensitive zone of Kaziranga National Park and Tiger Reserve. Decision of the meeting held on 26-27 January 2025 under the chairmanship of the Honorable CEM on the matter related to mining in the proposed eco-sensitive zone of Kaziranga National Park and Tiger Reserve and other related matters. In pursuance of the above, the mining operation is suspended with immediate effect under Parkap Prahar Range jurisdiction for the stone quarries falling under the proposed eco-sensitive zone of Kaziranga National Park and Tiger Reserve and within default ESZ of KNP and TR in compliance of the Honorable Supreme Court order in this regard. In view of the above, you are directed to ensure that all concerned quarry settlement holders stop mining operation in compliance of ban on mining in such areas as per order of the Honorable Supreme Court of India in this regard. This is for your information and further necessary action. All the concerned quarry settlement holders for information and necessary compliance of the above here on ban on mining. So, my lord, in a sweeping order, this imperial order bans stone quarries, about 11 or 18 of them, no? In this area. And so we have two petitions are there before your lordships where all the legal requirements were complied with. And your lordship has gone through the clearances. All the relevant authorities have given the clearance. And, my lord, this is without any notice, without even jurisdiction, because the divisional forest officer is nowhere in the picture. If you have a power of suspension, it is with the competent authority, who will be either the director of geology or the chief principal conservator of forests, Assam, as per the definition below, which I will show. So this is what we are aggrieved by, my lord, because no opportunity, nothing. You don't make any inquiry. And what is the Supreme Court? Which Supreme Court order are you referring to? When this matter was first moved, first day, my lord, when it was moved, it was on 21/2/25. My learned friend was there and he said that he'll give the judgments. So they have filed an affidavit now. And your first order, your lordship has seen that. It was there. No. So, my lord, there are some admitted facts. We were asked to shift. We complied with the order. We prepared again the mining plan. It was approved by the concerned authorities. They allowed us to operate there. We have gone there, we have paid them, and we are operating. You don't give a notice to us. For a second time, we have done this, Miller. First time also the same procedure was followed, we were allowed, but they said, now you go there. We have come. It is not our choice, it is their choice. And they say that it is in compliance with the requirements of the law. And we have paid the dues. We have brought all our force, manpower, all our equipment, and we started operating. And without any inquiry, without any opportunity, this order now for 18 people, nah? 18 of them, 10 persons are involved, different persons, two of them are before your lordship. It all has come to a standstill. Because there are three consequences. One for the petitioners, obviously, because they have made an investment and all this shifting and again all this. The second is, my lord, the workers. They are in great distress. The employer has obligations for payment, and we are prevented from doing our work. Thirdly, my lord, it has a public element in the sense that this area supplies a major portion of the requirement of stone, and you have a lot of ongoing infrastructural construction in this area. And that was taken note of. I'll place that order of this court. So this is the situation. And now I'll show your lordship the requirement under the law, their own rules.
Minus.
The Assam Minor Mineral Concession Rules 2013. Page 245 of that book, Miller. My lord has got it.
Yes.
Will you kindly see the definition given of competent authority in clause E? Means the Director of Geology and Mining Assam in respect of minor minerals as listed in Schedule X, or the Principal Chief Conservator of Forest and Head of Forest Force Assam in respect of minor minerals as listed in Schedule Y, or any other authority specified by any government notification for exercise of such powers and carrying out such functions as specified in these rules. As far as we are concerned, this item is Y. Therefore, it will be the Principal Chief Conservator of Forest and Head of Forest Force in Assam. So he is the competent authority, Mirror. And that X and Y, your lordships will find at page 326. Funny? No. 361, I think. I'm sorry, it is 361. X is at 361. And Y is at page 362. There's no dispute. Last time also my learned friend said that it is Y. And boulder is at page 362, Y. Gravel, ordinary clay, ordinary sand. Hmm? Hmm? Hmm. Hmm. Now, my lord, if your lordships kindly turn to the rule 6 at page 327. This is the power of suspension which is prescribed under the rules. The director, my lord has got it, 6, page 327, my lord.
Part 5. No.
No,
Okay,
it is
6.
just above that, my lord.
Okay, suspension.
Suspension, 6. The director may order to suspend the mining operations after servicing a notice to the contractor in case the following violations are noticed: unsafe and unscientific mining, non-operations of weighbridge, non-providing of safety appliances to the workers, non-payment of compensation to the surface owners, non-submissions of monthly returns. In case of violation of the aforesaid conditions and also any other terms and conditions of the agreement deed and the provisions of the rules, the competent authority may give a notice to the contractor to remedy violations within a period of 15 days from the date of issue of the notice. In case the violations pointed out through notice are not remedied within the stipulated period of 15 days, the competent authority may, after affording an opportunity of being heard to the contractor, order the suspension of the mining operations till such time the defaults and defects are removed by the lessee within the time frame granted by the competent authority. During the period of suspension of mining operations, the contractor will be allowed only to undertake rectification work for removal of defects and shall not dispose of the minerals. During the suspension period, the contractor shall be under the obligation to deposit the amount of contract money on the due dates. So that is ensured to them. On satisfactory removal of the defects, the competent authority may revoke the suspension orders with or without any modifications, non-removal of the defects or defaults during the suspension period and within the time allowed by the competent shall lead to the premature termination of the contract. So this is the power.
No, but this is with regard to Schedule X.
Below, it may be Schedule X or Schedule Y, but
No, no, Schedule Y
yes,
is the PCCA.
no, that is not the, no, competent authority is prescribed below, that
Ah.
is a different thing at Rule 6
Hmm.
at page 327, no?
No. At page 245,
245, yes.
the competent authority.
Yes. Director
uh,
competent authority means Director of Geology and Mining Assam in respect of minor millers as listed in Schedule X, or the Principal Chief Conservator of Forest Assam in respect of minor millers as listed in Y. So this is the competent authority.
No, competent authority so far as Y is concerned
Yes,
is the principal chief conservator
Correct,
forest.
correct.
Ah.
Your lordship is right. That's why we are saying that DFO cannot issue this order.
Okay.
That's with regard to the jurisdictional aspect, that is our case. Now, suspension of mining operation is the power given to the director. So, director may order to suspend the mining operations after serving a notice to the contractor in case the following violation. This is the power for suspension. So, director is specifically the statutory authority given this power. And your lordships will remember that case, Ken Commissioner's case, 69 case, where the statute prescribed an authority. The chief minister exercised that power, and Supreme Court said that no, you can't, even the chief minister can't pass this order because the statutory authority specified alone can pass the order required. So suspension, as far as suspension is concerned, the director is now conferred the power for mining operations, which includes our operation.
This X.
So, I am not on that because, whether it is mining director or the chief conservator of forest is immaterial because the DFO in any case is not the authority to suspend. Let us leave that. Only see whether the director has been given that power. It's nowhere there. In fact, Milord, the director is now for both problems, possibly. That is why the given power is to the director. So that, Milord, when you stop the mining, the director of geology is the competent authority, and they have given that power to them. But in any event, Milord, even if we go by that definition which has occurred to your lordship, the DFO doesn't come into the picture. We are concerned with his power to give this order, one. So he doesn't get the power under the rules. Two, forget the rules also. Let us conceive this situation where, after complying with all these requirements for a second time, this is shifting, second time therefore, you are allowed. Will you be suspended without a notice? Forget this Rule 6 exists. Forget the grounds of this. On pure, simple premise that if you are going to pass an order to the detriment of the person concerned, you are obliged to give him a notice and hearing. That's what your lordships have held, starting from the 50s. And finally, in the election matter, countermanding, which is not prescribed that you have to give any opportunity to the voters, in Mohinder Singh Gill, the court said that silence of the statute doesn't decide this question. You are required to conduct the poll under the law. Therefore, if there is any departure from the law, any citizen can come and make a complaint. That's how, my lord, the natural justice was invoked, as your lordship too. So, see the position, my lord. I am complying with the law. Stone is a necessary requirement. It is a mining activity. It is governed by a law. And I have complied with everything. First time also, second time also. Let us forget the first time. Second time, all the mining plan was approved, environmental clearance was approved, everything. You are not making any allegations. You are not coming for any inspection. You are not talking of any water level going down, nothing. And you just blanket 10 persons, entire thing, entire area is still. Can it happen like that? That's the whole question. It's absolutely arbitrary, Now, what are they saying? The Supreme Court. Let us see what they have produced before your lordship. They have filed an affidavit. Kindly see the order. The first order is at page 47. Kindly see the note. The date 12/4/19. At page 48, below, item number 7, your lordship, the Supreme Court dealt with the applications concerning illegal stroke unauthorized mining in Kaziranga National Park, Assam, in petition number 20. What they are dealing with is illegal unauthorized mining in Kaziranga. First thing first, if I submit a mining plan as required under the rules below, and if the authorities at different levels find that this is all right, and the letter of the conservator of DFO to the director, your lordship has seen at page 21, that it is beyond 10 kilometers. And they admit, yes, this was given, and this outside, this is not agricultural land, there is no elephant corridor, there is nothing. That's their document, not mine. And that 10 kilometers is also doesn't exist today. I saw that, my lord. Out of anger, my lord, in a case, one judgment said, let it be 10 kilometers from the boundary as an eco-sensitive zone. But the government of India moved applications that modify this order. It can't stand. The villages will come, and that the judgment which modified that contains all these details. Large number of villages in different places will now, if you broaden it to 10 kilometers, it will come. And it will be counterproductive for everyone. So they said that nothing doing, this is not. And the only thing they prescribed was that Mining within a radius of 1 kilometer will affect. Therefore, until you have a law with regard to the distance as far as eco-sensitive zone is concerned, this is the prescription. 1 kilometer from your existing boundary. No, that's why the DFO is writing that at page 19, that it stands beyond 10 kilometers. If you take it as 10 kilometers also, it is beyond, on their own showing. So in any view of the matter, but 10 kilometers has gone. It is 1 kilometer now. And your lordships will kindly note, the eco-sensitive zone for Kaziranga has not yet been notified. So you have to go by that 1 kilometer, which the Supreme Court has prescribed. I'll cite those cases. So it is absolutely arbitrary, my lord. I can't conceive a rational mind having regard to the law will pass this order in an outlandish manner. You are affecting not only the persons involved, the laborers, the contractors, but entire developmental work is going to be affected. And that is a matter which was taken note of in this very proceeding, in similar proceedings relating to Kaziranga by this Honorable Court. I'll show your lordship that judgment. And where it was said that you shift, if you want, then subsequently then we got this shifting order, we have shifted as they wanted. Now again we are landed with this order. Where do I go if I don't come to your lordships? Absolutely arbitrary. Because on admitted facts, this is arbitrary. You yourself say that it is beyond 10 kilometers, this area. It has no agriculture, no passage for wildlife and all that. That's your own document. Now kindly see the orders now for a moment. This is dealt with at page Kaziranga 3, because they take a lot of other matters also. Then, my lord, if your lordships kindly turn to page 51, item is 7, your lordship has seen. Consider the report number 6 of 19, with 2019, with respect to illegal mining in Kaziranga National Park, Assam for short KNP. So they were considering illegal mining. It is not my mining, my lord. I have not done at any stage any illegal mining. I have complied with the law. They have given me permission. That's why I am operating, nothing else. Now kindly see. In the meanwhile, as certain matters are urgent as apparent from the report, following aspects are mentioned in the report number 6 of 29. Ban forthwith all types of mining and related activities along the southern boundary of the KNP in the entire catchment area of the rivers, streams, and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park. They wanted in the report that you should ban where? On the southern boundary. I was telling your lordships while I placed this that it is Karbi Anglong East Division and Western Range. So they are talking about a southern part of Karbi Anglong, not that part. And it is concerning illegal and unauthorized mining. So, ban forthwith, this was the report, not permit any new construction, including on private lands, which form part of the 9 identified animal corridors, it doesn't apply to us. Director General of Police was directed, and the SP of the Karbi Anglong, both were directed. In view of the aforesaid, last sentence of the page, we order that all kinds of mining and related activities along the aforesaid Kaziranga National Park area and in the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park, including Tiger Reserve Park, are restrained. No new construction shall be permitted on private lands which form part of the 9 identified animal corridors. The Director General of Police, Assam, and the concerned Superintendent of Police shall also ensure that no illegal mining takes place in the aforesaid area and no transportation of illegally mined materials take place from Karbi Anglong Hills. Issue notice to Karbi Anglong Autonomous Council and all that. So this was the order, my lord. It dealt with a report which dealt with on its turn in illegal and unauthorized mining. So they said that it is on the southern boundary of Karbi Anglong, and therefore they said you stop this and don't allow it to continue. We are not part of it. It is neither illegal or unauthorized. Ours is absolutely. So this could not have been applied to us. Then the next order is at page below 53. This is order dated 2011-24.
5 minutes.
Maybe more kapal ko. Well, at page 98. The items are there, Milo. And in respect to item 1, 2, and 4.
Item
1, 2, and 4. Page number 98, Milo.
okay. And the early order was with regard to
So that was in respect of 1, 3. That was in respect to item 3, Milo.
item 3. Who is the tender number here?
My lord.
The tender number?
Tender number you'll also find at page. The common tender, my lord, at page 31,
31.
my lord.
Okay. But
So my only submission will be like nothing. I mean, the only thing is that like reason has been given. My submission may be recorded. That reason has been given why it was rejected. Only that must maybe rejected. I mean, recorded lordship in page 281.
281, isn't it? But Dr. A. Saraf, the senior counsel, assisted by Mr.
You go, go.
D. Barua, learned counsel for the petition. Stop. Uh, The present writ petition has been filed by the petitioner, being aggrieved with the rejection of the
Rejection.
petitioner's bid with regard to item number one,
One
Two.
minute,
2
2 and 4
of 4
of the bidding.
of the tender notice number of the tender number 05/51 oblique 23 VM oblique PP GPL oblique 028 dash 05 without citing any reasons. Stop. The petitioner accordingly approached the authorities to know the reason as to why the tender bid of the petitioner was rejected. Stop. In reply, the who wrote this letter? The concerned authority.
This is, yes, this is written by Mecon Limited, who was conducting the tender.
Respond number
Oblique respondent number 2.
my lord.
Replied on what date?
And respond number 3
Three,
minute.
lordship, three.
Respondent number 3. Replied on what date is this?
My lord, this will be,
3rd March
my lord,
2025. Stating that during the evaluation of bids, you are MS Mukant
my lord,
of the petitioner's firm and Messrs. Deva, it was found that the two bidders had used the same IP address for uploading of their technical and financial bids. Stop.
we also gave a reply to that also, my lord, that is there.
The petitioner accordingly gave a reply
At page 283.
on 5/3/2025, stating that
We are at page 284. From K it starts, my lord.
stating that the tender documents. No, stating that there's no condition in the tender which provides that usage of same IP address would result in disqualification for a bidder. Stop. Para. No, continue. Learned senior counsel for the petition submits that all the necessary informations were given in the prescribed format and there was no suppression or misrepresentation on the part of the petitioner. And the action of the respondents is in violation of the
Tender conditions.
tender conditions. Stop. Para. Issue notice. Mr. A. Kalita, learned standing counsel.
I'm appearing from the government of Assam, state of Assam.
You're the government advocate.
No, Lordship, this here, Lordship, Industries Department has been made, so Industries Department.
Standing
Commission of
counsel,
Industry.
Industries and Commerce,
Respondent number 2.
appearing for the respondent number 2. However, submits that the reasons have already been given
Given reason has been already been given.
by the respondent number 3. 3.
Reasons have been given. Yes, Lordship, reasons have been given by respondent number
By the
3.
respondent number 3 to the
Three.
petitioner.
Referring to
Yes,
appendix.
Mention petition. I paid this one also.
To the petitioner by the communication
Dated 3.
dated 3/3/2025.
Right.
Stop. And therefore, no interference is
Required.
in the present tender process.
And referring to the Lordship, that clause A3 of that GCC,
And
that has been already read out by my learned senior.
yeah, and the reply further referred to clause 3,
A3 of
A3,
appendix 1 of GCC.
A3, appendix 1 of the GCC. Stop. Para. Mr. A. Kalita, learned standing counsel, Industries and Commerce, enters appearance, issue notice, on behalf of the respondent number 2. Any other party?
No,
No.
we have to take steps.
Petitioner to take steps for service of notice on the respondents 1, 3, 4, and 5 by registered post AD. Within 1 week? or
Yes.
Within 3 days. 3 days from today. Stop. Para. List, respondents are allowed to file affidavit. List after. Or should we give a date?
After 3 weeks, 4 weeks, not 3 weeks.
List the matter after 4 weeks. Stop. In the interim, the respondents, particularly the respondent number 3.
Lordship may refer to that earlier case also wherein a similar order was passed.
No, particularly respondent number 3 is directed not to finalize the not to finalize
Not to issue the final one.
shall not finalize the tender process with regard to item 1, 2, and 4
Four.
of the tender notice.
Bidding data sheet of the tender.
Hmm?
At the top, bidding data sheet of the tender notice, page 98.
No, after tender notice,
My lord.
very number, that same number you put 0551. That you will get it in page 31.
I'm applying.
Till the next return of
मैं नलो दस मैं अपना कार्य नलो আগৰ কেছটো অৰ্ডাৰ পাৰ্চন দি দিছো মোক এটা কপি দি দিবা
Sir, my lord, before starting my senior friend, my lord, yesterday I saw the concern, my lord, we have not filed a detailed affidavit, my lord, regarding whether it is my lord, boundary and what are the violation, my lord. If it is not inconvenient, my lord, lordship, we fix it on 20, my lord, we'll file the detailed affidavit. We have already placed the order of the Supreme Court. We have not filed a detailed affidavit, my lord, regarding whether principalship concept of forest has already passed the order, only the DFO communicated the order. Those points we have not clarified it, my lord. If your lordship grants some time, my lord, if my senior friend is agreeable, my lord, on 20, my lord. Or any other, my lord, that point, my lord, I am on, as on today, my lord, I am not in a position to clarify that point, whether the principalship concept of forest has passed the order or the DFO only communicated the order, my lord. And that point required clarification as my senior friend has already argued it. And the schedule why, my lord, principalship concept of forest is the appropriate authority, my lord. So if your lordship grants, I will file a detailed affidavit by Tuesday, next Tuesday. Lordship will fix out Thursday, my lord. It can be.
You have already filed an affidavit.
No, only, my lord, we are bringing the order of the Supreme Court.
No, you have done everything.
Detailed affidavit, my lord,
No.
and we have the map, my lord, regarding the boundary of the Kaziranga National
No,
Park.
no,
That
sir.
map we have already, my lord, produced a copy, my lord, and regarding all those points, my lord, regarding the principalship concept of forest.
20 is when next week.
Next week, Thursday, my lord.
We
And-
can, okay, then let them file an affidavit, a detailed affidavit and then.
The only thing your lordship will see, when we first move 21 to 25, the same thing was said. We'll file an affidavit, let us wait. So he is here and I am saying it. Court asked me and I said, all right, do it. I did not press for the interim prayer. Therefore, the court said that it will be kept open. It came before another learned judge. His lordship also kept it open. So if you still today again say the same thing that I want to file an affidavit, then I will very respectfully submit, my lord, that your lordship kindly see the entire, your lordship has seen basically the substance of the matter, my lord. This is something which is permitted by them to be operated. We are operating without any violation. And my lord, now they are passing an order without giving an opportunity.
See, senior counsel,
Yes, my lord.
what this court is proposing, in
Yes.
the other two orders, there's no mention with regard to the interim prayer.
Yeah.
This court would like to record once that if the case cannot be heard and disposed of
Hmm.
on 20,
Hmm.
prayer for interim shall be considered on the date.
My lord, that has already been done twice.
But it is not recorded in the.
Yes, it is there.
Last occasion, my lord, the petitioner took time to file the reply on our affidavit. On the
No,
reply,
no,
they are
what-
taking the
what-
point that DFO has not the power. So on that point, in the earlier affidavit, we have not clarified.
No, we have taken that point in the first case also, first petition also. What are you saying? Here. It is first order, my lord.
Second order.
First order, last.
Right.
Last line, my lord. Meanwhile, the learned counsel for the petitioner will furnish the extra copies. The prayer for interim will be left open to be addressed before this court on the next date fixed. That was on 25. Then the
Yes.
next date came, my lord, on 28 to 25.
It is kept open.
Again kept open. Therefore, my lord, your lordship has seen the basic substance of the matter. One, the authorities competent to approve have allowed mining. Two, no notice
That part is there.
have been given to us, and the obvious consequences are flowing now. And the Supreme Court order, if your lordship see, it is only 1 kilometer now. I'll place that case if your lordships want. Just place the judgment.
Anyway,
is-
we'll hear it on 20, then otherwise we can prepone it to 18th.
If the
Tuesday.
holiday is there, my lord, then we can file it on only Monday, my lord. It may not come, my lord. So Thursday,
It should come.
my lord. Tuesday, my lord.
Tuesday we'll have it.
My lord, Tuesday.
Coming Tuesday.
Tuesday we'll have it.
Only your lordship will kindly make it part. Your lordship is hard so much and I have taken the trouble to trouble your
No, no, I'm
lordship.
not keeping it parted. This court will be here.
Okay.
We'll heard Mr. P.K. Gosamil and the senior counsel, assisted by Mr. B.B. Bora, learned counsel for the petitioner. Mr. S. Chutia,
Jai Sutia.
J. Chutia, learned standing counsel,
Najigitari,
KAC,
Kitari.
prays for a short time
Hmm?
to enable him to file a detailed counter affidavit. The prayer is allowed. List the matter on 18th. Can you do it?
My lord. If it is 20, it is better, my lord. We will take time earlier. Holiday is there, my lord. So taking all the factual report and all these things, everything will place it, my lord. If it is not inconvenient, my lord.
On 20.
Okay.
It is made clear that if this case, this matter cannot be heard on the next date fix, the prayer for interim shall be considered. This is an interesting case.
My lord. My lord. Division bench, my lord, also, my lord, regarding illegal mining, my lord, someone moved the petition, my lord. As the case is pending in the Supreme Court, division bench did not say that the will not take up this matter. It should approach the Supreme Court. All this, I will place all these things, my lord.
No, no.
In the next date, my lord.
Milord, I can understand.
And we have
If it
given an
is
undertaking,
illegal
my lord.
mining, I can understand.
My lord, we have given an undertaking to the Supreme Court in the last occasion that we will close all the mining. So, my lord, we are doing
That
it.
was given when? That is
No,
important.
last
uh,
Don't talk.
2000 in December
Chutia.
2024, 11, my lord.
Chutia, subject to correction.
My lord.
Those cases which is before the Supreme Court,
My lord.
these are with respect to all the illegal minings happening in the different
Eco-sensitive zone, my lord.
in the
No, no,
Eco
no.
National Park.
Eco-sensitive zone, you have not yet
Okay.
specified.
Now here the case is
Stop the mining.
they've been given the permits
Ah.
by the concerned authorities, including the
My lord.
all these.
Well,
I think
yes.
three authorities.
Environment, then the impact
And
committee.
if there is any violation, my lord, then we can only the 60 days notice is required to be given before
Yeah.
termination, my lord,
Yeah.
as per rule.
Therefore,
So place all these things, my lord.
we cannot say that the petitioner is doing an illegal mining in
Right.
this case. That we cannot say.
My lord.
So if you want to close it, you'll
My
have
lord.
to follow the rules.
Your rules, my lord. Yes, my lord.
If you have not done it, then
Yeah, my lord.
it has to
That
go.
is all, that is all there is to it.
My lord. Good
That's
tale.
it. But you file your affidavit.
My lord, detail will.
Let us see
if
what
there is any
happens.
violation of the my lord, terms and conditions, my lord, whether it affects the review weights originating from Karikalam
You
to
can't
Kazunga
introduce
National Park,
all,
will place all these things, my lord, in my lord affidavit, my lord.
you can't introduce all this to the impugn order. You have not mentioned anything of the kind. You have never inquired. What are you talking?
Masamlas.
The order-
we
order-
know
Order speaks of nothing.
nothing.
My lord. But the report is there, DPO's report is
So
there.
your-
will place it, my
Your
lord.
report, you can do it.
Your affidavit
Will
cannot
disclose all these things, my lord.
cannot improve that order.
My
That's
No,
one
it
thing.
can't.
My lord.
So all these aspects
Yes,
you have
my
to
lord.
keep
My
in mind, and
my
then
lord.
let us see what happens.
My lord.
Lordship, I
Nine.
wish me not because your lordship had for an hour. I mean, I
It's
hope
okay.
your lordship is here. On
Yeah,
the-
I'm here.
Your lordship has fixed on which date now? Yeah,
20.
20th.
20.
As your lordship.
This is
9.
same order.
Same one,
Who is that? Same order.
same one.
Same order.
10. Hearing. Parter method.
Lordship on 23rd had heard it in great detail. And then Lordship, by the way, had to respond. What we have done in the meantime is made a detailed, comprehensive written submission, which we'll give, which sums up the entire case and the case law. They will also be doing that. But just in 2 minutes, if I recap, give Lordship a quick recap. This was Lordship against the Industrial Tribunal's order for on the application of the trade union. In our tea garden, our case was 6-7 points, and I'll give a copy of our written submission. Only one paragraph I'd like to give one to Lordship. And one to I. If Lordship would just come to page 2, para 1A. That's the sum of the case. It is why we have challenged the order is the following facts have been ignored. Point number 1, the employees are already being paid all the statutory dues, including pension under the ATPPF rules. 2, the retirement benefit scheme of 71 gave a clear option to the employees to choose gratuity in lieu of pension. Then that clause 7 was the operational one. Point 3, not one employee opted for pension. They all took gratuity. From 71 till date, no one has objected. Then, Lordship, they cannot espouse the case because ultimately in the cross-examination also they have accepted it, which we showed Lordship in detail. And then, Lordship, on page 3.6, that for the doctrine of espousal, and I showed Lordship the case law, some worker had to come to the union. The union cannot unilaterally do it. So we argued that also. And last, we had used the argument of delay and latches. So then Lordship had been kind to say that we'll give you one more date to the learned colleague on the other side that you may address on all these specific points or anything. So that's where we were. I thought I'll give a quick review, overview of that.
Have we got a copy of this?
Oh, yes, I have. My lord, I have prepared a statement of fact in brief, my lord. It will be. And here, my lord, this is the first, this is on in the first clause, my lord, point 1, my lord. My submission is that, my lord, the employees are represented under by the Sangha, my lord, that is under provision 36 of Industrial Dispute Act. There is the confusion about it.
Give me the dispute set. Oh,
Because if he is a member, if an employee is member of the Sangha, he is always well represented by the Sangha before any legal body. Section 36. And the Sangha has been established in 1958, my lord. Since then, my lord, and the Sangha represents the members of the union. Has a lot about it.
yes.
36. Representation of party. A workman who is a party to dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or under office bearer of a registered trade union which he is a member. Mine is a registered trade union, madam. If any member of the executive or under office bearer or of a federation of trade union to which the trade union referred to in clause A is affiliated, where the worker is not a member of trade union, if any member of executive or under office bearer of any trade union connected with or by any other workman employed in the industry in which the workman is employed and authorized in such manner as may be prescribed. An employer who is a party to a dispute shall be entitled to be represented in proceeding under this act by an officer of an association of employer of which he is a member. And in my case, my lord, he is represented by the General Secretary of the Sangha. So there is no doubt about it, my lord. And secondly, my lord, your lordship raised the question last occasion, my lord, of paragraph 4 of the writ petition.
Para?
Paragraph 4, page 4. Paragraph 4 of the writ petition.
Yes.
And their submission is that, my lord, that a petitioner begs to state that the employees have never raised any dispute regarding enforcement of scheme of 1971 in view of the fact that they are being provided the substantial benefit under the statute. It is pertinent to mention herein that for the benefit of the employees of the tea garden in Assam, the Assam Tea Plantation Provident Fund and Pension Fund and Insurance Fund Scheme Act, in short ATPPF Scheme Act, was enacted. Pension fund scheme was incorporated with effect from 1968. Accordingly, after the retirement scheme was agreed upon by the employees and management, the Payment of Gratuity Act had come into force as well. Pension under ATPF scheme act also came, and as such, retirement benefit scheme become refunded. That is a wrong submission, my lord, that I have clarified in my WS before the tribunal. In view of the above, it is a subsequent appointment letter. It was specifically mentioned that the employees after retirement will be entitled to gratuity under the Act and pensionary benefit under ATPF Act and PF Act 1955. Accordingly, the petitioner state is paying all benefit to the retired employees under the statute for all these years. Here my submission will be, my lord, Assam Tea Plantation Provident Fund Act scheme. It is, my lord, it is contributory, my lord. That is contribution from the management as well as, my lord, from our members. It does. And on that matter, I will take your lordship to my affidavit in opposition filed, my lord. Internal page. Internal page 4, my lord, of my affidavit in opposition filed before your lordship. Paragraph 7. Has your lordship got it?
Yes.
That the deponent does not admit the averment made in paragraph 4 of the writ petition. I have, my lord, denied their averments. Therefore, I will take your lordship to page 5. First paragraph. In this regard, the deponent denies the fact that the employees never raised any dispute before the management for enforcement of the scheme of 1971. In, my lord, page 5, internal page 5, paragraph.
Of your affidavit in opposition?
I am my affidavit. In this regard, page 5.
Where is that in
Page
this
5,
regard?
first paragraph.
It's a continuation of para 7.
Continuation of para 7, my lord. Next page. Internal page 5. First paragraph. In this regard, I don't know to got it.
In this regard?
Yes. The deponent denies the fact that the employees never raised any dispute before management for enforcement of the scheme of 1971, that is the gratuity scheme. In fact, the union on behalf of employees raised demand for revision of retirement scheme since 1979. It may be pertinent to mention here that whatever family pension is due under the Assam Tea Plantation Provident Fund and Pension Fund and Insurance Fund Scheme Act 1955, that is in short ATPPF Scheme Act, is from contribution of the employees as per the Act. And the management cannot deny the retirement scheme based on the that scheme. That is my stand.
Where is this Act, Insurance Fund Act 1955? And then
Tea plantation, provident fund and pension fund.
ATPPF
Ah, yes,
scheme,
my lord, that is with me, madam.
you have a copy?
This is my copy, my lord.
Under which provisions?
Yes.
I have an extra copy, but there is no dispute on that issue because we are paying under that only. That is the crux of the cases. We have to comply with the statutory rules, and we are. So that is not, and basically it says that it has to be paid by the employer, which we are doing. Just on a matter of.
That is, my lord, under this act, my lord. Your lordship may.
You want my? I can keep. By the way, you want my phone?
This is a contributory, my lord, and it is, my lord, different concept, my lord. It has no connection with the present case.
Yes.
This is my submission, my lord, on this point. And my lord, I have submitted my lord's citations, my lord, authority. And that is I have given, my lord, on last occasion. Yeah. That is part case, my lord, 2008 4 GLT 920.
Is this the one, your citation? No, this is your cite.
Which one, Lord?
This one?
This big one is mine.
No,
This is ours.
this yours.
We have given loose copy.
Loose copy.
Which one, by the way? 2017? Which case I can find it?
2008 4 GLT 920.
Okay.
Into. This is a reported case, my lord, first one, 2008 4 GLT 920.
1 minute.
Ah, you're right.
For your execution,
2000?
2008 4 GLT 920. This is the first case. The 2008 4 GLT, my lord, it is reported case, and next one is not reported. This is by Justice Rishikesh Roy.
Some more cases.
This is the one.
2008.
8 4 GLT 920. Management of Boisa Habit is there.
Yes.
Here, my lord, I will take your lordship to paragraph 12 first. Benefit receivable under the retirement scheme dated 23/9/68 was made available only to a specified class of employees who had joined service of the concerned companies prior to 1/1/1950 and who did not contribute to the provident fund scheme of the concerned company. This benefit was conferred through settlement reached through collective bargaining, and nothing was incorporated in the scheme to indicate that benefit payable under the retirement scheme would be withdrawn if similar benefit was made available to the workman under statutory obligation or some other obligation. When some pensionary benefit are agreed to be paid to a specific class of workmen through mutual agreement, the management, in my view, would not be right in withdrawing such benefit unilaterally, merely because some additional benefit by way of gratuity is required to be paid under statutory obligation. And they have withdrawn it unilaterally, my lord. And I will take your lordship to paragraph 14 then. the benefit under the retirement scheme is meant to be provided to only the eligible retiring employees who joined the service in the concerned companies nearly 58 years ago, prior to 1/1/1958. And it would be highly unjust to hold that the management is justified to withhold the pensionary benefit payable under a bilaterally agreed retirement scheme only because certain additional payment would be coming in the way of a retiring employee under the gratuity, which in my view was not intended to be a substitute or replacement for the retirement scheme. It is the law held by the in this decision matter.
In this case, if I'm not mistaken, you're given a choice, correct? Pensioner benefit.
Absolutely, Lordship has hit the point. In our case, that is clearly a choice was given. You either take this or that.
No, my
In
lord,
the
that's not-
relied upon case, no such clause existed. That is what distinguishes it. And we've dealt with it in our written submission.
No, that submission is against the law established by the Honorable Court, my lord. Here, my lord, Honorable Court, my lord, held that I am entitled to both pensionary benefit under the scheme, my lord, and gratuity under the gratuity. That is the law held by the on this one. Then, my lord, in next case also it is by justice. It is not reported, my lord, by Justice Koteshwar Singh. That I will take your lordship to paragraph 13.
1 minute.
Hmm.
WBC,
WPC 2717 of 2003. This case is not reported, my lord.
okay.
That is decided on order is 26/4/2012. I will take your lordship to
The
paragraph
order
14.
date is
That is, my lord, 30/4/2012, date of delivery.
where can I find it?
The first page, my lord.
On the first page.
Your lordship may take my copy, my lord.
Okay. Okay.
That is the law held by by Justice Singh, my lord. Paragraph 13 and 14, my lord.
Yes.
Thereafter, I will take your lordship to I will take your lordship to AIR 1968, Assam and Nagaland 39. On the same point, my lord.
AIR,
AIR 1968, Assam and Nagaland 39. Paragraph 4 and 6.
1 minute. AIR,
4.
She needs some.
Number Nudi Tea Company Private Limited.
1 minute. Nineteen
1968, Assam and Nagaland 39. Paragraph 4.
Yeah.
It says, my lord, next therefore remains the question whether on the scheme which are now before the court, namely annexes G and K, one can safely conclude that there was a pension scheme for life Mr. Cruz contends that there is no mention in any of these schemes that a pension was available for life. He contends that a grant of pension was a matter of discretion of the company, and this has been mentioned even in Annexure G dated 14 July 1946. We are not satisfied that after the modified scheme has been put in operation in 1950, there was anything left with the management to refuse pension as a condition of service to the retired employees in the company. After the scheme has been brought into force, it was no longer a matter of bounty, and the scheme has to be enforced. There is nothing in the scheme to indicate that pension was to be allowed for a limited period. This is the judgment by Honorable Apex Court, my lord. And thereafter, I will take your lordship to paragraph 6.
Oh.
Paragraph 6 said, we have no hesitation in holding that labor court's award is justified on the evidence, and we cannot interfere with the same in exercise of our power under 226 of the Constitution. The petition is dismissed. And thereafter, I will take your lordship to another decision, that is 2013 4 STC 141. Ahmed Bank versus AC Agarwal.
2000?
2013
Hmm.
4 STC. Paragraph 16, my lord.
Page 141.
Yes.
Hmm?
Yes, page 141.
Yes.
Relevant paragraph is page 151, paragraph 16.
Yes.
Says, my lord, in our view, the High Court's interpretation understanding of the judgment of this court is correct, and there is no merit in the argument of Sri Nariman that respondent who had received gratuity under 1972 Act is not entitled to pension, or that he must refund the amount of gratuity as a condition of payment of pension. This is very clear, my lord.
Yes.
And thereafter, I'll take your lordship to AIR 1951, Supreme Court 606,
1 minute.
Greenless Bank.
Para?
Paragraph 6. Here, my lord, any power of the court, my lord. Paragraph 6.
Yes.
We are of the opinion that tribunal has the power to pass the impugn order if it thought fit in the interest of justice. It is true that there is no express provision in the Act or the rules framed thereunder, giving the tribunal jurisdiction to so. But it is well-known rule of statutory construction that a tribunal or a body should be considered to be endowed with such ancillary or incidental power as are necessary to discharge its function effectively for the purpose of doing justice between the parties. In the case of the nature, we are of the view that tribunal should be considered as invested with such incidental or ancillary power unless there is any indication in the statute to the contrary. We do not find any statutory prohibition. On the other hand, there are indications to the contrary, my lord.
Hmm.
So, my lord, my submission is that, my lord, the award passed by the tribunal is a very reasonable award, my lord. Your lordship may not interfere with the award. And I will make two submissions, my lord, regarding, my lord, that is one AIR 1988 Supreme Court 2168. Paragraph 10.
AIR?
88 Supreme Court 2168.
Yes.
I will take also to paragraph 10, my regarding power of interference by the paragraph
Yes.
10. The object of enacting the Industrial Dispute Act and of making provision therein to refer dispute to tribunal for settlement is to bring about industrial peace. whenever a reference is made by a government to an industrial tribunal, it has to be presumed ordinarily that there is a genuine industrial dispute between the parties, which requires to be resolved by adjudication. In all such cases, an attempt should be made by court exercising power of judicial review to sustain as far as possible the awards made by the industrial tribunal instead of picking hold here and there in the awards on the trivial point and ultimately frustrating the entire adjudication process before the tribunal by striking down award on hyper-technical ground. Unfortunately, the order of the single judge and of the division bench has resulted in such frustration and had made the award fruitless on an untenable basis. So, my lord, my submission will be, my lord, the award has very rightly been passed, my lord. Your lordship may not interfere with the award. That is my statement. Huh? Yeah. Okay. And another decision on this point I will submit, my lord. 1983 for SCC. For SCC minus 156, that will done. On the same point, my
Para,
on the same point.
para.
Para, my lord, and given. Para 3, my lord. 83 for SCC negative. 83 for SCC 156, paragraph 4, my lord. Paragraph 3, my. Regarding your lordship power to interfere.
Okay.
That is my humble submission before your lordship.
2 minutes rejoinder if lordship permits.
Just a minute. Would you like to submit your arguments or written arguments, or this will do? Facts.
And this will do, my lord. I have already submitted my written.
Okay.
Lordship, there are two broad issues which we have covered in our written submissions also. One is the case on merits, one is on the question of maintainability. The maintainability aspect has two legs. One is, of course, delay and latches, 71 till date. The second is the doctrine of espousal, that you are a stranger to the dispute. You cannot, which is the union, come in if there is no worker that has complained. So on that point, lordship may again come back for a minute to section 2K and section 36. 2K defines industrial dispute. Section 2K.
Section
2K. K for king.
Yeah.
2K. Industrial dispute means any dispute or difference, and lordship may mark, between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or the terms of employment or the conditions of labor of any person. There is no word about the union. It is about work, employer, 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 workman, workman, workman. That's an industrial dispute. Section 36 is dealing with the union. Let's come there, Lord. May I read out? 36. Representation of parties.
Yes.
Representation of parties. Please mark, Lordship, a workman who is a party to dispute. Very important. A workman who is a party to dispute shall be entitled to be represented in any proceeding under the Act. Then, Lordship, the union steps in. Therefore, before they can step into a dispute, there has to be a workman who has to have a dispute with the employer. That is not there. So this section deals with what is the doctrine of espousal, on which I gave the judgment. Now, Lordship may come to page 12. I am only summarizing it, so
Of
saving
your argument.
argument, Lordship. I can show it from the file, but I have reproduced. Para 14.
Yes.
It is absence of espousal and lack of a valid industrial dispute. Section 2K and Section 36. It is pertinent to highlight that in the present case, the dispute has been raised by the Assam Sa Karamchari Songo, Naharkotia Circle, a registered trade union represented by its secretary. Notably, the only witness presented for examination before the learned tribunal was the secretary of the trade union himself, who is not even an employee of the petitioner. And these are the excerpts. Please see, Lordship, what he says to the tribunal. In his cross, I have not mentioned the name of any worker who sought to receive both gratuity and pension. I have not submitted any list of worker who was willing to receive gratuity and pension. I have not submitted any kind of documents pertaining to the worker who raised the issues of reference. So it unequivocally establishes that the secretary is not representing even a single employee in this dispute. Furthermore, it reinforces the fact that no employee authorized the trade union to espouse their cause or approach the tribunal for a grievance. Then, Lordship, I have reproduced section 2K. And then I produce the law. Last point, Lordship, is on page 21. And I'm done. Page 20, Lordship, bottom. Just one sentence. Page 20. It's only to point out their judgment that they are relying on. Please turn to page 21, bottom. Lordship, above the bottom is the highlighted point on page 21. Nothing was incorporated in the scheme. In my scheme, that clause 7 is there. So I'm distinguishing the case. So in my respectful submission, Lordship, I've argued that they are a stranger to the dispute, delay and latches, and that's the sum and substance of my case.
Let us see that scheme once.
Yes, Lordship, of course. That is on page, in the main petition file, Lordship. 1971 is at page 15, Lordship.
1 minute. With petition.
Yes, Lordship. Page 15. Annexure A.
Some petition. This is not the. Annexure A.
Yes, Lordship. Page 15.
Please, 1 5.
1.5.
Hmm.
It starts, Lordship, retirement benefit scheme. First paragraph is relevant. It is agreed between the parties that the existing retirement and pension scheme as per agreement of 25th January 55, as subsequently revised, will be replaced by the following scheme named as retirement benefit scheme of 71. Now, Lordship may come to page 17, clause 7. bottom of the page above the signature. Employees retiring under clause 2 above may exercise the option of gratuity in lieu of pension as provided in the clause. Duly signed. So, Lordship, no objection by the worker. No objection by worker. Everybody took gratuity. Nobody took pension, which I put on page 2 of my written submission, all the arguments. That's the crux of my case. I must be very grateful to Lordship for hearing this over 2 occasions.
On this, my lord, I will file a written submission, my lord, on this point.
You want to file a written
Yes,
submission?
my lord, I'll make out a copy to them.
Okay, heard Mr. N. Kohli, learned senior counsel, assisted by Mr.
Anshul Malik and
A. Malik, learned counsel for the petitioner. Stop. Also heard MSA Bhattacharjee, learned counsel for the respondents. Then now, when can you submit it? I'll fix a date. You need not be there. Heard in part. List the matter again on
After 2 weeks, my lord, any day.
3 weeks.
I know.
In the. I just put it on.
1 minute. How many respondents are there? You're there for the. For the respondent 1, huh? 1. You're for 2 and 3?
19. Okay. 26 March. 26 March. It may be 26 March. And my lord, your lordship may note, my lord, I have submitted 2 documents. One is synopsis and another is statement of fact.
No, that's
in
fine.
brief.
That's fine. You're appearing for respondent 1 only, isn't it?
No, respondent, my lord.
1.
I am for the respondent 1.
Hmm.
2 is presiding officer, 3 is statement.
And Mr. Leonard, standing counsel. Leonard, government advocate for the respond number 3. Huh? Stop. 13 part, right?
26.
List the matter again on. You want it on 26th?
26.
That's a Wednesday.
If it is 26, it will be very convenient, Lordship. Subject to Lordship.
And that's
The
only for submission, there's no problem. Okay.
Grateful, Lordship. So
26.
deeply.
Issues. How many matters are there?
Okay.
Of 2023, isn't it?
True of 2024, my lord. That is the leave to file by third
Leave to
party
appeal.
review.
1 minute. Okay.
The other CMA is for condonation of delay.
Hmm.
In fact, the review petitioners, the applicants were seeking for review of the impugned order as a result of the order which was rendered due to one agreement made by the rival parties in the other case. but the rights of the present applicants were affected, and although they were not a party in that case, so they have filed this review and the connected miscellaneous application.
Mm.
As prayed by the OP Council on the last occasion, my lord,
Mm.
they have filed their objection
Mm.
against the leave to file a review by third party.
Mm.
And the main contention in their written objection is that some other person had claimed to have purchased the disputed land. But the fact remains that there are no such sale deed, and the cause of action, according to the applicants, arose due to cancellation of their house pass as a result of the impugned order. The cancellation order was also made in the name of the present applicants. So unless this application is allowed, my lord, the present applicants would be condemned unheard.
Were you parties in the trial court?
Sorry, my lord,
Were you parties in the trial court?
we are not a party in the trial court, my lord.
You were not the party in the trial court.
The rival parties in this case,
So
They
you
have-
have no locus. Isn't it? I can pass the same order which you have annexed in your review.
yes, my lord,
petition.
just like that, my lord. Only
Yes, other side.
My lord, I would like to submit that they have no locus standi.
That's
Point
why
number-
I'm saying.
Yes.
So I'm dismissing this leave to file an review petition. However, giving them liberty to approach the civil court.
Yes, my lord, just like that.
Approval of
like
the
that.
redresses.
Yes, my lord.
Okay,
Yes, my lord, without the influence of the impugned order.
okay, heard Mr. Victor L. Ralte, Learned Counsel for the applicants. Uh, who is for the state?
I'm here, Your Lordship.
Your good name, please.
Miss Lalnun Louis, Your Lordship. I'm appearing on behalf of respondents number 3, 4, 5, 6, and 7, Your Lordship.
How about 1 and 2?
Yes, Your Lordship. Sorry, my apologies, Your Lordship. From respondent
one
number
to 7.
1 to 7, Your Lordship.
1 to 7, okay. Also heard MS, you give your spelling, please. Now we will be finding it difficult.
LALNU
L-A-N?
LAL, Your Lordship.
My lord, her name is in the course list,
It's in the
Oh, it's in the cost list. Okay, okay. Where's the cost list?
GA for R1 to 7. Lal Nun Louis.
Okay, this thing is there, no? Learned Government Advocate for the respondents 1 to 7. And MS Valentina, isn't that? Valentina Lantin Pui,
Yes, my lord.
Learned Counsel for the respondent number
12.
12. How about 7 and 8?
8 to 11, they do not contest. They were not, they have no more interest.
This is in same application 2 of 2024. Huh? By this application, the applicants are praying for leave to file a review application against the order dated 26/11/2014
Yes, my lord.
passed by this court in CM application number 203/2014 in RFA number 35/2013.
My lord, if I may, I apologize for the interruption, but if I may be allowed to submit 2 or 3 points, my lord.
Yes.
Because, my lord, this cannot be allowed because their pass was issued only in the year 2070.
That's why I'm dismissing this appeal
Oh.
application.
Okay, my lord.
You want to submit more?
No, my lord, no. Apologies, my lord.
Now, where did I stop? On the ground that if the if the leave to file a review petition is not allowed, the applicants suffer would suffer uh, would to file the review application, it would have an adverse effect without giving an opportunity to the applicants, without giving an opportunity of hearing to the applicants, as they were not implicated in the set RFA number 35/2013. Stop. Para. After hearing the learned counsel for the parties, comma, this court is of the considered opinion that the applicants who were not parties in the trial court, as well as before the appellate court, and in that view of the matter, comma, the applicants has no locus standi to file the present application. Stop. Accordingly, the present application is dismissed. Stop. Para. However, comma, liberty is given to the applicants to approach the appropriate civil court for redressal of the grievances. Stop. In the event the applicant approaches the civil court, the concerned civil court, comma, the same shall be taken up in accordance with law and without being influenced by the order dated 26/11/2014 passed by this court in CM application number 203/2014 in RFA number 35/2013. Okay. All right.
Yes, my lord, deeply obliged.
Your other applications also all stands dismissed
Yes, my lord.
in view of the order passed today in same application, huh? This same application 2 of 2023 is also dismissed. Review review petition 4 of this in view of the order passed in same application. This review petition is also dismissed. Okay.
Deeply obliged.
Item 12 of daily list, hearing.
Okay, none appears for the parties. List after 2 weeks.
My lord, in this case, have been appointed as an amicus by this honorable court. Application, my lord. My lord, I pray for some accommodation in this matter.
Yeah, amicus.
Yes, Chakravarti for the respondent.
Okay. Yeah. Okay, heard, Mr.
S. K. Chakravarti for the
Learned
petition.
counsel for the petitioner. Mr. S. Chakravarti, learned amicus curiae. Appearing for the respondent number 2.
Yes, my lord. Respondent number 2.
Okay, okay. This is on request made by Mr. What they heard, S.K. Chakravarti, learned counsel for the petitioner, as well as MSU Das, learned government advocate for the respondents. Number 1. On request made by Mr. S. Chakravarti, learned amicus curiae. List the matter after
2 weeks, my lord. Can it
Can
be
it be
on
on
1st of April?
List the
1st of
matter
April.
on,
This is a hearing day, 1st April.
okay, 1st April.
Right.
14 and 15.
None appears for the parties. You are there? None appears for the parties. List after 2 weeks.
16,
My lord, my lord, in this, my lord, in this case, the respondent, sole respondent is represented by senior counsel. He is stated to be on legs in another court, my lord.
Who's the counsel?
Mr. A. Das Gupta.
Okay,
So I've been asked to make a mention on his behalf, though I'm not in this case.
okay. Heard Mr. R. Sharma,
Okay.
Tribunal counsel for the petition. On request made on behalf of Mr. A. Das Gupta, Learned Senior Counsel for the respondent.
Yes.
When do you want?
Only one. Only one.
For the respondent?
After 4 weeks?
List after?
2 weeks. I've been asked to make a.
After 2 weeks.
17, 18,
Can I have a date, my lord, so that I can inform the senior counsel?
We'll have it in April.
April. End of March. I've been requested to apprise the lordship to pick this matter in the end of 27th.
March will not be 2 weeks.
27th of March.
Okay. Is it all right, Sharma?
If it is in first week of April, any date, because
Okay. Third April.
Obliged.
Well, it's in your prayer, well, this mathematics and part of the film.
Why?
Well, actually, today I could not prepare this case because I'm some.
When you're coming down from Delhi or you are here?
I'm here now.
Yes.
I'm here.
You are here?
Yeah, I'm here. I'm
I
here.
was going to impose course.
Now it's a permanent here, my lord.
First or third, whatever is convenient.
First is my lord.
First.
Heard Mr. R.B. Fukan, Learned Counsel for the petitioner. On request made by S.K. Medi, Learned Standing Counsel, Railways.
Really?
When do you want?
First April, my lord.
First or third, whatever. I suggested first or third, whatever.
First
Third is better for me.
First is written.
First is.
Okay, please, matter on. Finish.
Well, Pukun is not permanent here, my lord.